Hello viewers and welcome to this special interview. I'm Emmanuel Munyarukumbuzi and today we are with Michael Butera, who is a Chief Technical Advisor at the Ministry of Justice. We are here at the African Court on Human and People's Rights in Arusha, Tanzania, where we've assisted to a public hearing the last 2 days in the case that opposes the Democratic Republic of Congo and Rwanda on allegations of territorial violation of territorial integrity and many other allegations. So, Mr. Michael, would like to start with taking stock of the last 2 days. For somebody who has not been around, what should they know or what is there for them to understand?
Thank you. Actually, also to start with the correction, it's not extraterritorial jurisdiction. Rather, it was a human rights violation dispute, and so we've gone on for 2 days, and basically the whole entire case was around two issues, which one is jurisdiction of the court to hear this case, and admissibility, whether actually this case should be accepted and be heard in this court of law. And the case revolved around basically that this case is not about human rights violations. The case rather went far beyond the scope of the mandate of this court, where it ventured into the use of force, including as far as war crimes. It talked about sovereignty, peace and security, which are issues that are beyond the court's jurisdiction, the powers that the charter gives this court, which is the strictly speaking as violations of human rights and not other matters as you've seen. But the whole entire case is relying on that. Now, on the other ambit of the case was about admissibility, and we're raising issues including that there was no exhaustion of local remedies, which is a requirement of this court, that before you actually appear to this court or before you move this court, you should have exhausted local remedies, and that wasn't done at all. And then we raised another issue, which is about the evidence, the type of evidence and the nature of evidence. And we moved the court to understand that all the allegations are contained into in mass media publications, speeches by the officials of the DRC, which again they don't pass the test of admissibility. So this is why we really moved the court and submitted on issues of preliminary objections.
Well, talking about the evidence that is heavily relies on or articles or information disseminated through mass media, they had an objection that Rwanda used exactly the same thing to talk about the genocide. What do you have to say to that?
No, those are totally different two contexts, right? The genocide against the Tutsis that they cited, that actually Rwanda also relied on, it wasn't matters of evidence in court of law, right? When we had cases in court of law, including the AfCHPR, we were not invoking what was said on the media. Rather, we're actually holding accountable the actual mass medias that actually were perpetuating all these genocide propaganda. So this is totally different, and we were of course surprised that that DRC was trying to compare the two contexts. But I do understand, in the first place, this wasn't even an issue of contention in this court of law.
So what about the accusations or allegations of Rwanda committing genocide against some people in DRC? What do you have to say to that? Because they mentioned it during their oral presentations.
So to be specific, they mentioned about the genocide against the Hutus, which was absurd and completely took us by surprise, because one, that wasn't an allegation contained within the submissions they submitted to this court, so we weren't going to respond to that matter. But also, second, we do realize that this is a connection to a much bigger propaganda issue going on in the region. And we could very quickly draw the similarities of what they've been trying to do in the East African Court of Justice, they've been doing in these political forums. So I guess they couldn't lose another chance in court of law. So we are very much concerned, and I think the minister alluded to this, that the DRC is trying to use the court as political theater, and we're not going to allow that. And we brought this to attention to the court, that the courts shouldn't be used as political forums. And so DRC, of course, couldn't lose the chance to highlight what have been now very much long known recycled allegations that Rwanda is doing. If anything, actually the opposite. But we couldn't submit that because we're not doing facts. So it's still an issues. The issues that are being contended upon whether actually the court has jurisdiction. But of course, DRC went, beyond and above to bring all these facts and evidences, which are not facts, but evidences to be examined by the court. So we didn't respond because we were trying to remain within the scope of the submissions, which was preliminary objections and not the merit of the case.
So this case has many firsts, one of which being that it's the very first interstate dispute that has been brought in front of it. What does that mean in terms of jurisprudence? What does that mean in terms of the DRC using yet another platform to play politics?
Yeah, and I do understand the situation of the court, that it's first dealing with the first interstate dispute, and also second that it's a very highly politically charged case, and that might go both ways. So it really belongs it belongs to the court how they go about it. But first is that the court might want to remain very vigilant and stick to the principles of justice, and then ask the real questions of what's happening in the Congo, and in that case they're likely to find actually who is the real culprit. On the other side, they might, unfortunately, and I hope it won't, be moved by the very dramatic scenes that we saw in the court, where DRC has been using this over a period of time. They've been taking us where we go in artificial intelligence conferences. They bring all these accusations. We go into climate change conference. They bring these accusations. So it's now has become almost a custom. And the only remaining platform was definitely courts. They were very suckered. They remained far from the reach of this politicization of all these issues. But unfortunately, now we've been dragged in this court, and unfortunately for the court as well, it has to deal with all this. So we hope that the court will remain vigilant to this and actually decide issues of law, decide facts that are relevant to its jurisdiction, and not any political questions to be answered.
Thank you very much. You've talked about the inadmissibility of the case. Now what's next?
So we pleaded our case, and so was the applicant. So now we have 90 days as the rules of the court prescribe. We'll have to wait for the 90 days, which is roughly 3 months, and see what comes out. But mostly the case, again, the court will be deciding on issues, whether it has jurisdiction and whether the case is admissible. If of course it's an affirmative, then we'll have to go into the merits of the case, and if the court decide in our favor, then the case will be dismissed, which we hope that will be the case. But that's what now is next.
Thank you very much for the explanations and talking to us.
Thank you.